Good morning. Just want to give a little overview on what a Social Security disability attorney does, what they do not do, and how they get paid, because this comes up every time we take on a new client. So let's get into it. Social Security disability is very regulated when you have a representative, whether it's an attorney or a non-attorney representative. As you've probably seen, and currently, if you decide not to self-represent, which of course I'm very biased, but I think everybody should have an attorney or an experienced attorney in Social Security disability, and or an experienced non-attorney rep. Both are excellent, right? If you look at your SSA no, I take that back. If you look at the fee agreement that you are going to be asked to sign, these under the law have to include some very specific language as to the fee. You'll find that most Social Security disability professionals do not charge a retainer. The fee is also contingent upon prevailing on your case, and then the amount of the fee depends upon what your back benefits are. So if you're, and so the rule is 25% of your back benefits should you prevail, because it's contingent on prevailing. And that is capped currently at $6,000. It has been capped at that since 2009. So suffice it to say, the Social Security disability attorneys and non-attorney reps have not had a raise in 13 years, over 13 years. That is soon changing. They did do something effective end of November 2022, hopping that up to $7,200. So if they work on your case for 5 years, that particular agreement provision is going to still limit them to $7,200 as a cap. And if you happen to have back benefits that don't support 25% equaling $7,200, it's going to be something less than that. That's the nature of the contingency beast. You can perhaps make the full fee that's capped at $7,200 in 1 year, or it could be in 5 years. So that's the nature of contingency. You don't have to have a bill for all the work if you don't win, even if you don't win and it's all your fault because you didn't follow directions. So it's really protective to claimants, which I think is probably a very good thing. They probably should have a fee cap, in my opinion, that moves along with the same COLA increase as the beneficiaries themselves of Social Security annually. That way, no one has to worry about waiting for this big jump from $6,000 to $7,200 and go 13 years without a raise despite inflation. But that's a whole nother thing. But you just need to know that you'll have a fee if you have back benefits, and the fee would be 25% of those back benefits, capped at whatever the current cap it is, which is currently $6,000 and will soon be $7,200. Now, if there is no back benefits, there is another fee method approved by the SSA, and that is called the fee petition. And this is where the attorney itemizes all of the work done and puts his billable hour down, and the total will be represented on the fee petition, and the SSA again has to approve the fee. I'm sure lawyers vary greatly on, and other reps vary greatly on what their billable hour is. Historically, and I'm not sure if this is going to remain, I know we had just voluntarily capped our fee petitions at the amount of the 25% that would have applied if the fee agreement applied, even though the same cap does not apply. I just chose to do that 15 years ago because I felt it gave a little bit more security to my would-be clients that the fee is never going to be what a normal attorney fee would be. And it's kind of nice to know what your fee is going to be. And so I just figured we would eat that. I don't know if I'm going to be changing that now that the fact that they wait 15 years, or in this case 13 years, to, you know, bring that fee up to something higher than it was back in the single digits of the 2000s. um that might be changing, but right now, and that's just peculiar to us. But your fee agreement is strictly for the legal work. Now you can have other expenses involved in your case. They tend to be very minimal, thanks to Social Security regulations that allow it to be. For instance, you do not have to um, pay thousands of dollars to your doctor to have him come in and testify as to his treatment and his opinion of you. This is different from state court, where medical records will not be the end of the story. And in fact, that would be hearsay, and the doctor has to come in and testify. Personal injury litigants have that as one of their expenses that they're going to have to pay. Because that is so high, a lot of doctors, I mean, most are going to charge thousands of dollars to take a half day off. And of course, that day is always floating because hearings and trials can be adjourned and postponed. Those bills are usually going to be thousands of dollars for each and every doctor you want to bring in. With the SSA, the beautiful thing is we don't have the same rules of evidence admissibility. So the records of your doctor can come in paper. It's wonderful. So that costs you only the cost of your records. Some providers don't charge for records. Some do charge. There's also fabulous rule under the federal law, under HIPAA, and I have a different video on that, that limits each and every request you make to your medical providers for your records, because there are numerous requests for each provider oftentimes, because we want to always get the updates as we head towards hearing or an appeal or whatever the case may be. So the high-tech HIPAA is another thing, but it can keep each request to under $10. So I'm going to leave it at that, and you can listen to that other video. It's a really great thing because it means that claimants can afford to work up their files for a better chance of prevailing in their Social Security disability case. Otherwise, most people who are no longer working will not be able to do it. So I appreciate the HIPAA law that provides for this affordable access to records when used in a particular manner, which is what we always recommend our clients use. And I appreciate the fee regulation, believe it or not, in terms of the 25% of back benefits. I don't necessarily appreciate the fee not being responsibly updated by the administration in a timely manner, but that's another issue. But going back to it, so you have a very limited discounted fee as it is. So if your attorney puts in 50 hours, you're not going to be paying 50 hours times $400 an hour or $100 an hour. You know, that's just not the way it's going to be. The out-of-pockets that you'll have, though, are those medical records. And for attorneys like me that really take advantage of the of encouraging our clients to allow the ordering of the records using the HIPAA provision we're talking about, the out-of-pockets are really negligible. This is only the last few years. So it used to be 15 years ago, this was not the case. It was so bad. You could be looking at $1,000 to get your records, and what client can afford that when they're not working? We have some wealthy clients, but usually it's middle, you know, the working guy, just like the rest of us, you know, middle class income, lower class income, can't afford it. So we've worked hard to embrace those laws and get them passed that will help claimants be able to afford to support their own case. Now, the difference comes in when you need a doctor to provide a clarification to his records. We refer to that as a medical source opinion. They are just generally a few questions, interrogatory in nature, just saying, asking about clarifications about, well, how much does that affect his ability to walk or sit or stand or be punctual, depending on the impairment. Some doctors will charge you for that. Some doctors will not do it all. I'd say the majority won't do it at all. They just refuse, and they have that right. It's a free country still, somewhat. So the ones that do provide the clarifications, some of them take it as part of their obligation to make sure you have what you need from their treatment from you. And those are the ones that I think are the most ethical and take their job seriously, and they care about their patients. Then you have others that are willing to do it, but they're going to charge you. And that's not necessarily, that's their business. But some of them will charge you $500 if they're going to lift a finger and fill out a 5-minute interrogatory statement. Sometimes it's just check boxes even. So those are the ones probably that I'm talking about the most. And as I alluded to, your medical records are your own expense. Remember, your attorney gets paid a discount. I mean, it's like at a discounted rate. They work a lot of free hours. They're not getting paid for most of their hours. And there's no big slush fund for, those that make $300,000 contingency fee on a personal injury suit, or, $75,000 on a divorce case because they charge you by the hour and you are required to pay a retainer to pay that. So they can draw out of it for every expense. That's not the way this works. This is a very compassionate field. For those that do it right, it's a noble field, I think, because those Social Security disability attorneys and non-attorney reps who do this for a particular reason of paying forward, paying it back, whatever you want to call it, they do it for the most compassionate of reasons. But in order to keep the roof over their head, they cannot be allowing these doctors to dictate what some of them are doing. We can't control whether they're going to provide you with a clarification to their maybe vague medical records on a few questions. But for those that are going to charge you, if they're going to tell you that your attorney should be paying for it, it's just showing their lack of understanding of how the legal business and the legal practice runs. They don't understand that your Social Security disability lawyer is not a divorce lawyer, does not have a retainer from you, did not require one, and is not getting paid as they work your case. They're not going to have the funding to pay $500 for a medical source clarification of the records that they didn't articulate well to begin with. I understand it's another form of revenue for them, and they can get it from their wealthier patients. But most of our clients are not wealthy, and after not working, which is the whole point of this whole exercise of pursuing Social Security disability or SSI, that money is simply not going to be there. The blood comes out of the attorney through the dozens and dozens of free hours of work. And for those of us that use disability assistance, we're paying those out of pocket to work on your case. So if and when your doctor says this, and not all do, like I said, most aren't even going to do an MSS, an opinion clarification. Those that do, the great ones don't charge. They understand what this is about. But for those that do, let it be known to yourself that that is not going to be something that's possible for the Social Security disability attorney who has already put in countless hours of free work on your case. It's just not going to be there. If you think about it, even someone who has just 50 clients at $500 a pop per year, and that's per doctor, for any doctor that would ask for this. So imagine if all 5 of your doctors, I mean, there would be it would not be in the black. It would be perpetually in the red, and all lawyers would leave the profession of Social Security disability. As it is, you might already know there's a great shortage, and that's because of the extremely discounted fee. So that those that, struggle to pay school loans, or, there's about 50 years worth of school loans payments, it's not going to be something that they're going to be able to do. And they hightail it to other more reasonably paying professions in the legal industry. But for those of us that do this and love it, which I do, it's my life's work for sure. The medical source opinion statements are not going to be something that your lawyer is going to pay by and large. There might be a rare one, and that's often would be maybe the guy that also has your personal injury case as well, or your workers' comp case, because he's making 2 forms of income off you. But for those of us that exclusively practice Social Security disability, we aim to be top of our game. So we limit everything we do to it. All of our learning time goes to Social Security disability. That's not going to be something you're going to typically find. God bless anybody who can do it. I appreciate them. So if you have any questions on this, or if you hear, your doctor says your lawyer should be paying for this, just as your doctor should not be paying probably your legal fee, your lawyer probably should not be paying your doctor fee. So look at it that way, and hopefully this will give you an understanding of why that probably won't happen. And you could tell your your doctor, that no, that lawyer is working for free and will be mostly providing free hours regardless if I win. So they don't have that kind of slush fund of fund money to float around. Okay. So if you have any questions, you know where to reach me. For those of you who are my clients, you are already aware of this if you've been paying attention. I know a lot of things get forgotten along the way because these cases tend to be marathons and not sprints. But anyway, feel free to ask, and I'll give you, for clients, I will give you personal time to explain that further if this video doesn't quite do it for you. Okay. And I wish everybody the best on their cases, everybody who is disabled and unable to work substantially. You deserve to prevail in that instance. So anyway, you know how to reach me if you need me, and we'll talk soon.